now, George Zimmerman's fate for the shooting death of Trayvon Martin in the hands of the jury. Tonight, with the end of the trial, tells us about the verdict that may come and the impact that verdict will have outside the courtroom. Next, Spitzer's star on the rise again. New numbers plus lots of new petition signatures to get him on the ballot, leading Elliot to La La Land and Jay Leno's couch. And finally, can anyone explain what a Sharknado is, or why people care, or why people are talking and tweeting about it today, and why they would hate watch something on TV? Good evening and welcome to RFL. I'm Andrew Whitman, in one more time for Richard French. Thanks so much for joining us on this Friday evening, July the 12th. Trayvon Martin, just 17 months ago, few people beyond the town of Sanford, Florida had ever heard that name. We do now, because on the night of February 26, 2012, Martin crossed paths with neighborhood watchman George Zimmerman, and we all know what happened next. Zimmerman shot and killed the unarmed black teenager. But what we don't know is whether Zimmerman's actions were justified, at least according to the law, and that is what the six-woman jury in his murder trial are now trying to decide. For the latest courtroom developments, we turn to our own Dominic Carter. Dom?
Well, good evening, Andrew. The jury, the six women, will decide whether George Zimmerman goes free or to prison. Their deliberations continue as we speak. It is decision time. The jury given their instructions.
Your verdict should not be influenced by feelings of prejudice, bias, or sympathy.
And after 14 days listening to attorneys and witnesses, taking notes about evidence and testimony, they're finally deliberating over whether George Zimmerman is innocent or guilty. The defense presented their closing arguments this morning, maintaining the 29-year-old killed Trayvon Martin in self-defense, using computer animation to demonstrate Zimmerman's claim that Martin attacked him.
There's the shot to the nose.
Saying the 17-year-old slammed Zimmerman's head onto the concrete, leaving the former neighborhood watch volunteer with no choice but to shoot.
But that's cement, and that is not an unarmed teenager with nothing but Skittles trying to get home.
The prosecution firing back, given 1 hour to rebuke and try to convince the jury one last time that Zimmerman targeted Martin and that he is guilty. The jury began their deliberations at about 2:30 this afternoon. They have three options. They can acquit George Zimmerman, convict him of manslaughter, or convict him of second-degree murder. Andrew?
All right, Dominic, thank you. And of course, we're keeping a close eye on developments in the courtroom in Sanford. If anything happens that you need to know about, we'll take you right there live during the course of this program. But let's talk about the case with tonight's panel. Along with Dominic, we're joined by Mayo Bartlett, attorney and former chief of the Bias Crimes Unit at Westchester County District Attorney's Office. Richard Willstatter is back with us tonight, criminal defense attorney and former president of the New York State Association of Criminal Defense Lawyers. And Doria Davis returns tonight, journalism professor at Marymount Manhattan College and contributor to Communities at the Washington Times. And let me start with the counselors at the table tonight. Did we learn anything from the summation that we've heard over the last couple of days or the charging of the jury that gives us some insight as to where this verdict may go?
Well, I think the summations more or less followed what the testimony was. What was surprising to me is that the prosecution really was not as forceful with the summation as they could have been. They asked the jury more or less to speculate about a lot of things, and the defense more or less again painted Trayvon Martin as an aggressor, indicated that George Zimmerman had no issue, nothing other than to defend himself by firing a fatal shot. What I found interesting with respect to the charge itself is how different the law is in Florida than it is in New York. I was speaking to Richard about that earlier, and from state to state, it's just vastly different. In fact, in New York, you'd have 12 jurors in a case like this with 3 alternates in all likelihood, and the law itself is extremely difficult.
Richard, what caught your eye?
In this case, the prosecutor in the rebuttal summation really focused on the allegation that they have to prove that Mr. Zimmerman didn't believe that his only choice was to kill this person. What they said in their rebuttal summation was that he made a decision. He wanted to, but he didn't have to kill Mr. Martin. And that's really what they have to prove. Under the jury instructions that they have in Florida, they have to prove that he reasonably believed that he had no choice but to kill Trayvon Martin. And I think that they have a very good argument in that regard, but it's going to be highly contested. We'll have to see.
I just want to give everybody an update. We're just getting word out of Sanford that the jury has finished its deliberations for the day, that they are going to resume tomorrow and continue during the weekend. So if we were hoping for a quick verdict in this case, we're not going to get it. And I wonder, counselors, anything to read into that? I mean, a very quick verdict would have been, well, probably would have been, what, throwing the case right out? Is that?
I think a very quick verdict could have been a verdict for the prosecution. I don't see an acquittal very quickly. I think that there's a lot to at least contemplate. And in cases like this, especially when they receive so much attention, and my experience has been that the jury tends to take its time and really go through it. So I would expect it to take at least several days. Yeah,
it's a long day. They had the defense summation, they had the rebuttal summation, they had the jury charge. There's a lot of evidence to review. If I were them, I'd want to take a break.
As I was watching the summation and some of the coverage today, Zimmerman's defense attorney said, you know what, not only are we going to establish reasonable doubt, we're going to prove that Zimmerman is innocent in this case. I wondered if that was perhaps a misstep on their part, because if you say we're going to prove he's innocent and the jury says, I give you reasonable doubt but not innocence, do they penalize George Zimmerman for that?
Well, number one, again, we go back to the fact that George Zimmerman decided not to testify, and he could have given testimony which would have showed exactly what was in his state of mind. Instead, everyone's being asked to speculate what was in George Zimmerman's state of mind. The jury heard information and were charged with respect to stand your ground. And the thing that was neglected, at least in terms of what I was able to see from the prosecution summation, is that Trayvon Martin also would have had the right to stand his ground. And if, in fact, George Zimmerman was the initial aggressor, Trayvon Martin was not engaged in any unlawful activity, he could have stayed right where he was, and he would have been justified in defending himself. And the difference is he did not have a weapon at the time. George Zimmerman knew he did. Trayvon Martin was a teenager, and he would have been justified in using his fists. So I'd go to the analogy, if you start a fight with Mike Tyson and he happens to win, it doesn't make Mike Tyson wrong.
That's true. I guess it's your mistake for getting into the fight in the first place. I want to reach out to the non-attorneys at the table. And Dory, I'm curious what takeaways you got from watching the trial and where you think this might be headed.
Well, first of all, the defense started out with a knock-knock joke, as you may remember.
Right.
So if the jury doesn't hold that against Zimmerman, they probably won't hold a lot else. But I think that the prosecution did drop the ball in a big way on second-degree murder. They did not prove it. And I'm not a lawyer, but if I were on the jury, I wouldn't find him guilty of it. So the question for manslaughter is going to be, do they think, as we said earlier, that Zimmerman thought he was in mortal danger? And I think they will be haunted by the fact that he got out of the car when he was told not to get out of the car, because if he hadn't got out of the car, all this would be irrelevant.
Richard, I'm curious, do you think that plays in this case, the admonition from police to Zimmerman not to get out of the car? Is that something that can be held against Zimmerman?
I think it will, because Zimmerman is going to confront a person because the person is black, is walking around in his neighborhood. He runs up to this person and a fight ensues. He didn't have to do this. The person actually wasn't committing a crime, so he's got to deal with that. But it all comes down to what happens during the fight. In my estimation, it's going to be, does the jury believe, beyond a reasonable doubt, that George Zimmerman thought he had to kill this guy? That's what it comes down to.
But in a wider question, how is anybody ever going to know what happened in that? I mean, there was nobody there. We have some scant physical evidence as to what may have happened. How is the jury supposed to reach that conclusion that Zimmerman either had no other choice or did have another choice?
Well, the defense chose to put Zimmerman on Hannity, and he gave a really, I think, damaging interview on Fox News where he went through things that he really didn't need to get into and said he was not familiar with stand your ground. They later called his college professor who said, no, he knows all about it. He's one of my best students. We talk about it all the time. There are lots of inconsistencies based upon his unsworn testimony on Hannity and what other people have said he's told them, which has found its way into this trial. But there's also the testimony of the medical professionals who say that the injuries are superficial And his own counsel in summation today said he exaggerated his injuries. So if you're exaggerating your injuries, now a jury can sit there and say, well, maybe he really wasn't hurt so badly. We know that he wasn't, and we know that you can bleed a lot from a head injury. So what else is he exaggerating? And maybe he never really feared for his life. So that alone, even though the prosecution, and I agree, did not really go and prove that, he may have proved it based upon his actions in court and outside of the court.
Dominic, your takeaways?
I think we can all agree that the prosecution dropped the ball on murder 2, but the threshold, let's remember, is very high. What you have to prove. I mean, obviously the lawyers have illustrated, over the last couple of days, what you need to do is not as high with manslaughter. What we have not considered, in my opinion, and I covered Howard Beach, Bensonhurst, all these major racial cases, and I put this one right in with it, Bernard Getz, and so on. We have not considered the emotional element. And there's just no way in the world that 6 women, that's why the prosecutors were brilliant in this respect, all women on the jury. I just don't see a scenario where they're just going to let him walk out of the courtroom. I'm sure some of them possibly are mothers on that jury. And when the judge, it was a major blow for the defense when the judge permitted manslaughter, because that's a compromise. Okay, they didn't prove murder 2, but the compromise is manslaughter.
Does the rest of the panel think we're headed for manslaughter?
The most likely scenario, if there's a conviction, is that it's going to be for the manslaughter, because they have to prove ill will and spite, and the evidence is obviously weak there. So the jury could feel, well, they didn't prove that, but they proved the manslaughter. But again, it's going to come down to whether he's justified or whether he had any other choice other than to kill Trayvon Martin.
And quickly, Mayor, you think we're headed for manslaughter?
I think it could easily be manslaughter. I think there's a possibility of an outright acquittal, but I think that there's also a possibility that he could be convicted of the top count. One thing that didn't find its way into this case is the fact that Zimmerman had been charged with assaulting an ATF officer, assaulting a law enforcement officer before this, and that Zimmerman had made multiple calls to the police before, and each and every one of the people he called, he described as an African-American male.
All right, we're going to take a quick break. When we come back, more on the Zimmerman case, not so much from what we've seen inside the courtroom, but what the impact might be beyond the courtroom. That's next. Stay with us.